Thirdly, the judicial review of the administrative action exists in India even before the Constitution. The law courts could draw upon the common law principle of justice, equity and good conscience, and the relevant statutes to the correct illegalities in the administrative action and give relief in its suits filed for that purpose. Even after the Constitution, when the high courts are empowered to exercise the power of judicial review of administrative action under Article 2 to 6 of the Constitution, these reliefs can still be obtained by way of suits. This is sufficient to show that the Constitution was not to wipe out the pre-existing law which was not inconsistent with the Constitution. This is confirmed by Article 372 of the Indian Constitution. The reason why the Constitution had to be made the supreme law was that in addition to judicial review of administrative action, the superior courts had to be given the power of judicial review of legislation. These two powers of judicial review are distinct from each other and are exercised at two different levels. The rule of law is therefore to be distinguished from the rule of the Constitution or that of the higher law in India. Even if the latter or a part of it is suspended when the enforcement of certain fundamental right is suspended during emergency, the former would continue to operate. The suspension of the rule of Constitution or of the higher law is intended to make legislation temporarily invulnerable. It can have, however, no effect on the rule of the ordinary law, which is directed mainly against illegalities of the administrative action. No difficulty is therefore experienced in the coexistence of the Constitution with the pre-existing law. It is to be noted that the fundamental rights are guaranteed expressly by Article 13 only against inconsistent legislations. Similarly, the Constitution is supreme law against any inconsistent ordinary law. Therefore, friends, the fundamental rights and the rest of the Constitution would prevail against administrative action. This should not, however, cloud our understanding of the basic purpose of the Constitution, which was to provide the supreme law as against the legislation. For before the commencement of the Constitution, ordinary legislation, however unjust, it had to prevail against the liberties of the people based upon the common law or the principles of justice, equity, and good conscience. Friends, the effect of the Constitution was to place the fundamental rights and the other provisions of the Constitution above the ordinary law and to protect them against any inconsistent legislation. While legislation can be challenged as being inconsistent with the Constitution, administrative action may be reviewed on totally different grounds, such as being based on malefides or irrelevant considerations, or being without jurisdiction or showing apparent error of the law on the face of the record, etc. The existence of the Constitution and the remedies given by it are not a sine qua non for obtaining judicial review against administrative action or by way of suits, even though a more expeditious remedy may be available by way of writ petitions when disputed questions of fact are not involved. It would appear, therefore, that the suspension of the enforcement of fundamental right during emergency should not affect the ordinary remedy of judicial review of administrative action without seeking the enforcement of a fundamental right as embodied in the Constitution, and not challenging the validity of any law but restricted only to the validity of the administrative action on the above mentioned grounds, all of which have existed from before the Constitution. Even after the making of the Constitution and enactment of relevant statutes, the ecology of the Constitution and the statutes is formed by that part of common law which has been received in India as rules of justice, equity, and good conscience, as suited to the genius of this country. This much of common law is in force in India as recognized by Article 372, Clause 1 of the Constitution. A 9-judge bench of the Supreme Court of India in Superintendent and Legal Remembrance Corporation of Calcutta case, which was decided in 1967, had this to say about the common law in India. It is well known that the common law of England was applied as such in the original sites of the High Courts of Calcutta, Mumbai and Madras, and that in the Mufassil courts the principles embodied in the common law were invoked in appropriate cases on the ground of justice, equity and good conscience.